Okay, we're ready, Jerry.
Good morning to everybody. I'm Gerasimos Rosados. I am the Acting Director for the Oil Conservation Division, and I'm also the Acting Chair for the Oil Conservation Commission. I'd like to bring into order our meeting that we have scheduled for today. It is the rulemaking that we have. So we'll start up our meeting with a roll call. As stated, I am Gerasimos Rosados. I am the Acting Director for the Oil Conservation Division and Acting Chair for the Oil Conservation Commission. And I'll go to the commissioner right next to me.
Good morning. I'm Greg Bloom. I'm the designee of the Commissioner of Public Lands. Thank you.
Good morning. I'm Dr. William Ampoma, designee of the Energy Secretary. Excellent.
Thank you all. So we've got our roll call. Next, we need to do the approval of our March 11th and 12th, 2022-5 agenda. If I could get a motion for the approval of the agenda.
I so move.
I second.
Excellent. So our agenda is approved. As stated, this is our pending case. It's case number 23580. It's application of Wild Earth Guardians to amend the Commission's rules to address PFAS, amendments to 19.15.2, 19.15.7, 19.15.14, 19.15.16, and 19.15.25 of the New Mexico Administrative Code. This is going to be the Commission's deliberations. So I want to open it up and we can start deliberating. Commissioners.
Mr. Chair, I don't know if you have any ideas about how we work our way through this. I think, however, one approach might be to just start at the top and work our way through it. I think we'd get pretty quickly into the mix on some of the bigger issues, or we could just, each spend a few minutes talking about where we're at with the case in general.
Thank you. Commissioner Ampoma, did you have any?
Not really. I feel like if you look at NMOCD's summaries, really reflects a lot. They compare the petition and then also that of NEMOGA's position. So I think that will be very helpful, and also the one that the council also prepared for us. So either way is fine with me to go.
Excellent. I do have one question for you, commissioners. We could definitely go one by one, as Commissioner Bloom stated. Is there a preference on potentially taking a holistic and just adopting one set of suggestions? For instance, Wild Earth Guardians, NEMOGAs, or the OCDs?
I will say that it's probably one after the other, because maybe we might not all agree on adapting just one single suggestion.
Excellent. Commissioner Bloom?
Mr. Chair, I think I agree with Dr. Ampoma there. I don't think any one set of proposals encompasses where I would land, and I'm not sure that it would for the entire commission either. So I think working our way through from the beginning might be fruitful. And just something to put out there. One thing I've done in the past, I think we did rulemaking on the pit rule back in 2012 or so, 2013. And we kind of, found our way through, looked at some areas where we agreed and that could set those aside, and then dealt with some of the trickier issues at the end. Although in this case, I think there's a few big issues out there that we just need to get into.
Excellent. Well, then let's start one by one.
Dr. Ampoma, I think you were saying that going through the the OCD exhibit was helpful in terms of getting us side by side. And
I think so. That was really, really helpful. But let's say if we even start from the beginning, we can still cross-check that with what OCD has in terms of the comparison of all the proposals, and we can agree or more or less discuss.
Okay, we can totally do that. I apologize. I just had failure of my electronic device, so it'll take me a second. If you all would want to start with the first one.
With the first one, so the petitioner is proposing a definition for chemical. I kind of side with OCD because this is a common industry term. And if we intend to define that with regards to this rulemaking, probably there could be some limitations to the scope. So I agree with OCD that should be scrapped.
I would coincide there as well.
I actually have to agree with that also, so I think we would stick with what the OCD stated for that one. Excellent. And again, I apologize. Can one of you just say the actual rule number that we're looking at? As I said, mine kind of collapsed.
Sure, that was rule that was 1915.2.c, 4 and 5 NMAC. It's the definition of chemical, which we would remove from consideration. It was proposed by the joint proponents.
Excellent. Thank you.
And then I believe the next one right after that is number 5, which is the definition of chemical disclosure list. And that is a term I would want to retain because it comes into play later on when we get into questions about do we allow trade secrets or proprietary information to be retained in frac focus. I think it's time to let the sunshine in and drop the trade secrets. I'm glad to elaborate more on that if there's any discussion of it.
I actually would like to hear some more on that, if at all possible, from you, Commissioner.
And Mr. Chair, if you want, we could take a few minutes here. You can pull up your documents. I know it's distracting to try and.
I apologize. Everything just kind of
Just
went
hit pause
haywire.
for a second. No, we've all been
Yeah,
there.
if we could just take a minute, if you could give me 5 minutes and we'll be right back on record. Thank you. My apologies to everybody. We're back on the record. Commissioner Bloom, you were discussing a specific rule. If you could just restate it for the purposes, and we just get back to it.
Yeah. So let me move up the page here to find that again. Okay. So before our pause there, we were looking at proposed changes of rules to 1915 2C5. And that is the addition of a definition for the term chemical disclosure list, which means a list of all chemicals used in downhole operations at a well site. And let me just set the stage for this. This comes to play a little bit later. If we look at citing here, OCD's exhibit binder that they used for the hearing, and this is page 32 of that 101-page document. And there is another definition for undisclosed chemicals for 1915 2. U is an under 3. And that reads, undisclosed chemicals means either chemicals that are listed without a chemical abstract service number in the frac focus database pursuant to 1915-16 19B NMAC, or if a safety data sheet lists ingredients that comprise less than 100% of the whole chemical product, those chemicals that make up any unlisted portion of a chemical product in a safety data sheet. I believe this becomes important too with page 35 of the PDF. We see WEG's proposal, the joint proposal of 1915-7 16A NMAC, where it says that within 45 days following the completion or recompletion of a well, the operator shall file Form C-105 with the division accompanied by a summary of special tests conducted on the well, including drill stem tests, and the addition is, and the chemical disclosure list. In addition, the operator should file a certification that no undisclosed chemicals or PFAS were used in the completion or recompletion of the well. So we see this term going through. So this would be these would all be terms that we would want to keep if we're interested in bringing sunlight to what's being put into the ground, what's being released into the air, and what's being spilled on our ground. If you'll permit me, Mr. Chair, my notes here for this, but this section, I think NMOGA noted in its opening that PTFE, PFAS chemical, had been used up until 2020. FPEG was used up until 2015. And the only reason we know that about the use of these chemicals is because they were disclosed. Had they been held as trade secrets, we would not have known anything about them. There are a lot of PFAS chemicals, potentially hundreds of thousands, that have not been safety tested. We heard that testimony during the course of this hearing. That could be used, currently in New Mexico if we don't implement this rule, if we don't implement it broadly. They could be hidden as trade secrets. I think there was some talk from NMOGA that we cannot ban trade secrets at the OCC. I don't believe we would be doing any such thing. It was the OCC which allowed the use of proprietary information when it set up its disclosure rules and linked our state to frac focus. And what the joint proponents have offered is language that says companies can keep their chemical formulas secret. They just can't use those chemicals in New Mexico. If you want to use it here, you have to publicly release that chemical information. And I think this is really important because, as we heard from Ms. Troutman with the proponents, we've had massive numbers of spills over the past, I think, the 10-year period that she looked at. One of the figures that stuck out to me was there are almost 5 million barrels of spilled fluids and oil and gas spills totaling about 5 million barrels, 2 million barrels of which were never recovered. And we really don't know what was not recovered. It could have been other PFAS chemicals. They could be out there in use today, and we have no idea of it. These chemicals we know are incredibly toxic at a level of not parts per million or parts per billion, it's parts per trillion. And the vast, vast majority of them have not been safety tested. Parts per trillion, we're talking about a drop in 100 Olympic swimming pools. I think we heard another figure tossed out during the hearing was 1.5 ounces would contaminate 100,000 acre feet of water. An acre feet is enough water for 2 or 3 houses for a year. It's hundreds of thousands of gallons. So the toxicity of this is almost, I mean, at a level where it's unfathomable. And they haven't been safety tested. It's being spilled on the ground. We heard testimony that can be evaporated into the air. We don't know what happens with that. We've had very little testing. So I believe if a company wants to bring chemicals into New Mexico, transport them, potentially spill them, may or may not report them, may or may not have them cleaned up, may kick dirt over them, as we see at the land office, in a way that's almost routine, frankly. We should know what chemicals are being used out there. This is not in violation of the Trade Secrets Act. OCC has done rulemaking in this area previously, and I believe we should do it now.
Thank you, Commissioner Bloom. Commissioner Mpoma, Dr.
Yeah, so Commissioner Bloom, with regards to, let's say, the chemical disclosure list, this is something that companies have to disclose more or less, like, let's say, through frac focus. Now, with regards to the trade secrets, I mean, if you say that if you define chemical disclosure list means a list of all chemicals used in downhole operations at a well site. I mean, how are we, well, like, let's say if you have company A, company B, there are some kind of trade secrets with regards to, let's say, a particular composition. So are you saying that, let's say, if we force companies to more or less disclose entirely all the chemicals that they are going to use in the downhole operations, are we not in violation of the trade secret?
Commissioner Mpoma, Mr. Chair, that's a good question. If we want to pull up the Uniform Trade Secret Act in New Mexico, we can certainly do that, but we would not be in violation of that because we would be saying that companies simply have to disclose the chemicals they're using, and they can't use anything that's not disclosed. So essentially, it's the end of trade secrets in terms of what chemicals would be used in oil and gas operations in our state.
And will that not hurt innovation?
Dr. Mpoma, I don't know how that would affect innovation. I was pulling up some of the frac focus disclosures randomly yesterday, just kind of going around Eddy County, and a good number of them had maybe 6 ingredients listed in their frac fluid, and they were all made public. I think some of the secret might be in the ways that they're mixed or put together, Is there going to be a degree of hardship for the for the companies? There could be, but I believe that's outweighed by the public's right to know, and I believe it's outweighed by our duty to protect public health and the environment. We can't protect ourselves from chemicals that we don't know about. This would create a much more open system, one with greater availability of information to first responders, people working on cleanups, people going out to sites. It would simply be jump on Frac Focus, see what's on that, see what was being used or transported to that job. So I think, our charge is to protect public health and the environment. It's not necessarily to ensure trade secret status for chemicals, which we now know are incredibly toxic. We've only, recently set EPA limits on about 6 PFAS chemicals. And there is a testimony we heard suggests there are tens of thousands or 100,000 such chemicals out there. Chemicals routinely come into commerce in the United States, and there's no substantial testing regime for them. It's been an ongoing problem.
So, Commissioner Bloom, I'm looking at one of the disclosures through Frac Focus. So you're saying that let's say they can list the ingredient, but so here the cash number, they are making it more like proprietary. So are you saying that, let's say, as long as they more or less disclose the ingredient and not necessarily the cash number, is that acceptable?
Dr. Ampoma, I would be anticipating that the ingredient, the CAS, the CAS number, and the percentage of the fluid would still be disclosed as we all those numbers would be disclosed to have a full disclosure.
Did you have any other concerns, Commissioner Mpema?
I want to hear from the council if you can chime in on this one, especially, let's say, with regards to this particular discussion, if we are not in violation of the trade secret. If we are not, then I do not have a lot of concern about this. But I feel like the competitiveness of companies can be more or less be restricted here if we are more or less allowing 100% disclosure, especially if it is marked as a trade secret.
So before you answer, Council, I would want to say that I kind of have the same concerns, that this may be overstepping our ability and authority with the trade secret laws. Though I share the concerns that Commissioner Bloom has, and we are dealing with chemicals that are definitely have the potential of hazard and toxicity, and it is this commission's one of this commission's goals to protect public safety and to protect the environment. I would never want to have this commission overstep its boundary into law that we have no jurisdiction over. So I do share the same concern that Commissioner Mpoma does.
This is Zach Chandler from the Department of Justice. I think both sides have laid out their legal arguments. I don't think there's a black and white answer I can deliver to you today. I don't know if the hearing officer wanted to summarize the different legal, just a neutral recitation of the legal arguments.
Yes, Mr. Chandler and Commissioners, my name is Felicia Orth. What the petitioner is doing here is not engaging in the sort of debate that, for example, NMOGA and even I think the division was engaged in, which is what happens when a company identifies a trade secret and then OCD has to take custody of it and protect it. And there's a fair amount of administrative work around that. That's not where they're engaging. They're stepping around the question of what happens when a company says, hey, that's a trade secret, to say, this is about disclosure. And you might have trade secret, right? You might have proprietary substances. You just can't use them if you're not willing to disclose them. So again, it goes back to disclosure. It's of a piece with the disclosure mechanism. And if they're not willing to disclose it, if they still want to characterize it as a trade secret, they just don't put it down the hole. So it's a stepping around the question, really, of what is a trade secret. That's how I read the competing arguments here.
But I remember that in the discussion, NMOCD made it clear that if there is a problem, then you have to disclose everything to NMOCD, but they would have to more or less, be careful with regards to how they disclose that to the public. So I don't think NMOCD was saying that if you cannot disclose it, you don't use it. They also give a path that if there's a problem, and let's say, assuming they have a cause of concern, especially if let's say your operations is going to impact on the ground source of drinking water, there you have to disclose that to them without any restrictions, but they will still protect that information.
Right. And so you're right. The division was aligned with NMOGA on this effectively, not with the petitioners who are saying that this is of a piece with the disclosure requirement. Either you disclose it or you don't use it, or a trade secret. And so I guess, Mr. Chandler, the place I think the commission might benefit from a legal opinion is, yes, certainly to the extent they are allowed to say, we want to use a trade secret, proprietary substance in our fracking, but does the Trade Secret Act entitle them to use something that's not a trade secret? So yes, once it's a trade secret, right, we know how to treat it, but are they entitled to use a trade secret down a hole?
Ms. Orth and Dr. Mpoma, when we look at the Trade Secret Act, it's Uniform Trade Secrets. It's a very short act, frankly, and it really works in the way, for example, if a company says that it has a trade secret, its employees would not be allowed to make those things public. Otherwise, they could face action in court. It does not give a company the right to say, I'm declaring a trade secret of this food additive, and then put that food additive on the shelves in New Mexico and not list the ingredients. It doesn't work that way. It's really about what happens once a company declares a trade secret, and how, when that trade secret is broken, it can be people can be sued in court. So I think I'm just looking at Google here, but
Can I interrupt 1 second, Commissioner
Sure.
Bloom? Though again, I agree with what you're saying for the most part. Trade secret, same law that you're looking at, New Mexico statutes annotated, Chapter 57 under Trade Practices and Regulations. So it's 57-3-2. The definitions under D, trade secret means information, including a formula, pattern, compilation, program, device, method, technique, or process that derives independent economic value, actual or potential, from not being generally known to and being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure. So formula is part of that. That is covered. The division, as Commissioner Mpoma brought out, stated that it would also cause a burden on them because now they're having to maintain the trade secrets, that it would not in its daily activities unless there was a spill that was justified. And at that point, the rules of the spills come in and they have to disclose. So there is a little bit of a distinction here of what is disclosed and what isn't, and how that affects legally and also how it affects the division.
Mr. Chair, I don't believe there would be any burden placed on OCD because they simply would not receive trade secrets. Companies could not use anything that hadn't been disclosed on Frac Focus. So any knowledge that would be out there would be public, and there's probably less of a burden on OCD if we only allow the use of disclosed chemicals. And I agree that chemicals can receive trade secret and formulas can have a trade secret designation, but it doesn't, as we read the act, and you can go through it here, I mean, it's a few lines, there's nothing out there which says a company, a person can declare a trade secret and then have the right to use that. In fact, it was the OCC, wasn't it, that created the use of Frac Focus for the state and allowed for information to be held as proprietary. And this simply undoes that. I mean, think about this. We would have no idea that PFAS were being used in New Mexico if it hadn't been disclosed. They could have declared these things proprietary information and we would have never have known about them. And the numbers are pretty substantial. You can find those, one second here. I think it was I'll go back and find them later. Just the number of PTFE and FPEG that were used, the many thousands of pounds of it is really substantial when this stuff is toxic at the level of one drop in 100 swimming pools. There we go. It was looking at the joint proponents post-hearing closing brief for adoption, page 8. It says Mr. Horowitz's research indicates that during the time period, 22 oil and gas companies injected 227 wells with a total of 2,605 pounds of PTFE. Additionally, EOG Resources injected 34 wells with FPEG with a total injected weight of 6,400 pounds. Remember, this is in a situation where 1 ounce can make toxic for human consumption hundreds of thousands of acre feet of water or millions of gallons of water. Between 2013 and 2022, oil and gas companies injected 8,200 wells with at least one trade secret chemical per well. Trade secret chemicals used over this period totaled 243 million pounds. I mean, almost a 250 million pounds of released into the air, spilled onto the ground. We see them going down washes. We see them, we heard the stories of people pulling the plugs on water trucks and produced water spilled out on the road. We don't know what's in these. It hasn't been released. And we're, it's us. Like, we're up here protecting health. We're up here protecting the environment. And right now, the industry can take any chemical, call it a trade secret, and we have no idea it's in use. I mean, there could be an entire new class of chemicals invented tomorrow that would be put into use, and we wouldn't know about it for Lord knows how long, until somebody decided to voluntarily disclose it to us. But right now, any of these chemicals, I mean, even PTFE today could be in use in New Mexico and just held up as proprietary, and there's no protection. We need to put the cart before the horse here. We're bringing chemicals into commerce, into public use, into contact with the environment and people before they've been safety tested. And later on, we find out, how horrible they are. And we heard, ample testimony from the joint proponents witness that worked at 3M and that debacle. And, here we are again, trying to get the genie back in the bottle. And it's it's disclosure that allows us to know what's being used in New Mexico. So I'll stop there.
Commissioner Bloom, so I'm looking through OCD's closing arguments, and in the on page 4, item 15, or let's say 16, it is clear intent of the legislature that trade secret protections are beneficial. The commission does not have the requisite authority to either compel disclosure of protected information to the public or to ban use of such compounds simply because it is marked as trade secret. So, and also from, let's say, someone from a research background, this is very, very important. To me, I feel like if we go beyond this, then it means we are more or less restricting innovation. So I will still stick to my opinion that this should not. I mean, I was side with OCD on this one.
So let's take it as a vote. I'll just start just on the far right, Commissioner Mpoma. How would you like to go with this one?
I side with OCD and I scrap the chemical disclosure definition.
Okay. Commissioner Bloom?
I would leave in the new definition of chemical disclosure list so that we can get towards full public disclosure of all chemicals that are being used in oil and gas industry in New Mexico.
Okay. And my vote is actually going to be, I agree with Commissioner Mpoma and with the OCD that this is, it goes past the purview of this commission. And so we scratched the chemical disclosure list for this one. So that is a 2-1 that we remove the chemical disclosure rule on this. So 1915 2C5 will be struck under chemical disclosure. Excellent. Next one is the change of rule to 1915 2D6 downhole operations. Wild Earth Guardians proposes that downhole operations means oil and gas production operations that are conducted underground. The OCD suggested that that be removed, and I believe that's cited with New Mexico Oil and Gas. Yes, sir. Did I miss one?
Yeah, scrap that from their file.
Did they?
Still check that with the hearing.
I appreciate that. Madam Hearing Officer, did that one get scratched?
I believe so.
Awesome. Thank you. I appreciate that. So which one's our next one? Okay. So it's under P.
PFAS.
PFAS. So we'll move on to 1915.2, P as in Paul. Number 3, PFAS chemicals means a fluoroalkyl or a polyfluoroalkyl substance with at least one fully fluorinated carbon atom. That was the proposal from Wild Earth Guardians. The Oil Conservation Division wanted to modify it to read that PFAS chemicals means any chemical with at least a perfluorinated methyl group, or a CF3, or a perfluorinated perfluorinated methylene group, a CF2, excluding those with a hydrogen, chlorine, bromine, or iodine atom attached to the subject carbon atom. For the purposes of compelling environmental investigation, the specific PFAS chemicals that can be included in the chemical analysis includes those listed in the United States Environmental Protection Agency, or US EPA, Standard Analytical Methods documents, specifically Method 537.1, the drinking water, Method 533, drinking water, Method 8327, groundwater, surface water, and wastewater, Method 1633, wastewater, surface water, groundwater, soil, biosolids, sediment, landfill, leachate, and fish tissue, OTM 45, which is air, semi-volatile, and particulate-bound PFAS, and OTM 50, air volatile PFAS, including updated versions for each standard method. Commissioners.
So can the council comment on this one? Because this is the one that it was brought to our attention that the legislatures are looking at this. So I don't know if there is any guidance from the council on this one. I just need some guidance on this one.
So, Mr. Chairman. There you go. Mr. Chairman, you did receive a letter from the proponents updating the information about the legislative process for a particular bill. I think at this time there's no certainty about what that would happen. So the lay of the law right now of the land is that bill is just out there as a proposal. If the legislature then does adopt it at a subsequent date and it's signed, the commission can then evaluate the legal landscape at that time. But the landscape at the time is at this moment is it's just a proposal.
Okay, if that is the case, and also OCD scrapped the OTM 45, so they removed that portion from their definition. And from OCD standpoint, their definition will help them to be able to regulate. They believe that, let's say, what the proponent is providing here can be probably unenforceable. So on this one too, I will side with OCD's modification to the definition of PFAS chemicals.
Thank you, Commissioner Mpoma. Commissioner Bloom.
Thank you, Mr. Chair. On this one, I mean, again, I think we have a real opportunity here to do something to more widely protect public health, which is something we've been charged with, and to protect the environment. The NMOGA and the OCD definitions would very much limit the definition of PFAS, which would make a lot of chemicals eligible to be put into, or I guess to be continued to have use in the oil and gas industry in our state, when we know, I think what we heard was absolutely nothing about the safety of those chemicals. I don't know why we can't prohibit something without it being enforceable, Dr. Mpoma. You know, I was trying to think of some analogies to this, and you know, there are certain crimes that have very good clearance rates. For example, I live in Albuquerque, and we've got a bit of some crime going on down there. The clearance rate for murder is really high. I think it's like 85% or 90%. Almost all those cases are solved. But we don't see that private property is recovered from home break-ins. We don't see that vehicles are recovered when they're stolen. And yet those things are still prohibited or they're still illegal. we can make something, we can prohibit something that's, even though there's not a test for it today, there's still other ways to find out that a chemical has been used when it shouldn't have been. If we go with the proponents' definition of at least one fully fluorinated carbon atom, there could be other ways to find out that that chemical was used. For example, someone from a company could step forward and say, we should not have been using this chemical, and it was used, a sort of a whistleblower type situation. We are also putting down a marker that we're not going to allow untested chemicals to be used in our state. Again, where they're spilled onto the ground to the tune of 2 million barrels over a 10-year period, 80 million gallons of these fluids, which are potentially, and some of them being very, very toxic. I think casting a wider net here is absolutely appropriate. And I would point out the joint proponents mentioned that PFAS, this very definition of PFAS is used by 23 states and cited by the federal government. So this is not some quickly, thought up definition, but it's one that's in common use in nearly a majority of the states. I'm sure many states don't have them. So probably of the states that have them, this would probably be the most common definition. I think the last thing I would say is just because something can't be tested now, you don't get enforcement that way. The tests are growing. Future tests will be available. And we should use a definition of PFAS, and then a wide definition of PFAS. The other one last thing, and then I'll stop here, Mr. Chair, but I think Dr. Mpoma, during the hearing, you asked Dr. Richardson if a ban would impact NMOGA, and he said, I didn't think it would have any impact at all, to be honest. So, why not have a wider ban? If companies are supportive of this ban, let's go ahead and use it. Let's do something broad. Let's put health first and protect it.
Commissioner Mpoma, you look like you have a question.
Yeah,
I
so-
thought you were going to jump in. Sorry.
Commissioner Bloom made an important point that we have to put our foot on the ground in such a way that untested chemical cannot be used in New Mexico. Because I had a concern about when OCD say that currently not all PFAS compounds can be detected using standardized methods. So I kind of probably leaning towards your argument that no untested chemical should be used in New Mexico. So probably, you are pushing me to your angle now. Thank you.
So, and Commissioner Bloom, I'd like to just ask, in your mind, how does what Wild Earth Guardians and what OCD proposes differ? What's the big hang up for you between the two?
Mr. Chair, the definition of PFAS as put forth by the joint proponents would cover thousands and thousands of chemicals. And I believe the testimony we heard from the OCD and NMOGA is that their definition would cover on the order of like 100. So we're talking many, what's the word I'm looking for? Sort of 10x type, increases in the amount of chemicals that would be covered. I think there was some important discussion from some of the proponents' health experts on this, that you really can't regulate and protect from things if you don't know they're out there, if they're not disclosed, and if we don't have a wide definition of PFAS. We don't even know, what other chemicals might be being used, might be out there and shielded because of proprietary information or trade secrets.
So though I agree with you on the fact that the OCC is tasked to make sure that we maintain and protect the environment and public health. If you look at the OCD version, it states that with at least a perfluorinated methyl group, or a CF3, or a perfluorinated methylene group, without the hydrogen, chlorine, bromine, or iodine. And then it says, for the purposes of completing environmental investigations, the specific PFAS chemicals that can be included in the chemical analysis include those listed in the EPA testing. And then it says, including updated versions for each standard method. So I don't see how it's limiting to go with the OCD version when we're saying it is something that can, if we can see it, let's definitely test for it and get it done. Again, not saying that we shouldn't, I believe you opened up with your remarks to Commissioner Mpoma, Dr. Mpoma, that if we can't test it, we shouldn't have it. I don't necessarily agree with that statement either. But it was also told to us as a commission that something as important as Paxlovid is a 1 carbon perfluorinated compound. An SSRI that is commonly used is considered PFAS. So I think a broad statement is a lot, not that we're putting Paxlovid and SSRIs down a hole for drilling, but I believe on a chemical substance, on a chemistry background, the division's definition definitely covers what this goal of this commission is to protect public safety and the environment.
Commissioner, so if you look at OCD's closing statement on page 3, it says that all 3 proposed definitions of PFAS will result in the prohibition of the use of more compounds than are known to cause toxicological harm to humans. Now, OCD definition will prohibit about 40 to 70 compounds. The key point I want to make here is that on 8, it says OCD's proposed definition will evolve and expand with the field of study, prohibiting the use of any compounds identifiable through the described sampling methods. So, Commissioner Bloom, let me ask you, if we cannot...
Can I interrupt you?
Sure.
Commissioner, could you read 9 for us as well?
Okay. OCD's proposed definition is inherently precautionary because it will cover all PFAS compounds for which the scientific community develops a standardized testing method. So it sounds like OCD is trying to broaden their definition here, and it's going to evolve. Do you see the proponent's definition more or less evolving, or is just a one-time stop where even chemicals that we cannot even test it for is more or less automatically banned?
I think to take a step back and remember that these chemicals are so dangerous, so toxic that industry doesn't want to use them anymore. They're worried about the liability. They're worried that when they spill, it can get washed downstream. I mean, these are chemicals that don't bind to much anything. So they shoot straight through the ground. They go into groundwater. These are incredibly toxic. Nobody wants to use this entire class of chemicals. We have the opportunity to ban their use in oil and gas very widely, to the tune of thousands of chemicals. I mean, sure, Paxlovid is ingested by people fighting off COVID, but would we want to use those same chemicals downhole? I don't know. It might not be safe. How do they react to pressure and heat? Those tests haven't been done. And so what we're looking at is one definition, which would ban thousands of chemicals that NMOGA says nobody wants to use anymore. or the OCD definition of 40 to 70 compounds. Yes, it'll grow because some of these standard tests and methods will grow, but we don't have to adopt a standard that only encompasses what's enforceable. We can have a standard which essentially says there are thousands of chemicals that haven't been safety tested, and we leave those out. And tests will evolve over time, and of course OCD will have more ability to enforce over time as more tests become available. But let's protect the broader health. Let's keep a broad class of dangerous chemicals, dangerous to the parts per trillion level. Let's keep those out of public commerce, off our lands, away from human interaction, until we understand that that there's testing. If these things are deemed one, safe, and then two, of interest to industry, they can petition, come back, and reconsider. But I don't think covering a relative handful of the thousands of chemicals is sufficient when our charge is to protect human health and public health and the environment.
Mr. Chair, I have a question for you. So on number 10, on that same page 3, prohibiting the use of defined PFAS compounds from the use as downhole additives will not negatively affect the exploration, development, or production of oil and gas because the industry has phased out the use of PFAS. So my question to you is, does it really matter? The definition that we use, because, OCD saying even companies are moving away from the use of PFAS. So either proponent's definition or OCD's definition or NIMOGA's definition, does it really have any impact?
Are you asking my opinion?
Yes, I'm asking your opinion on that.
Okay. So the statement is correct. They are being phased out. And I think that's why the OCD is definitely in its closing arguments saying, as you mentioned, it started off that the proposed definition either way prohibits these compounds. I think, and I come more from a laboratory background. My background is in sciences and laboratories, and we like to see what we can see in our testing when you're a scientist from a laboratory background. So in my opinion, since you asked my opinion, I would tend to go mostly with what the OCD says because of the ability to be able to see the compound analytically. And in testing that the mechanisms that are in proper analytical procedures, you'll have your quality assurance, your quality control, and you'll be able to substantiate what you found based off of your testing protocols. If it was met the QA, QC information that you've put in place, and maybe even if you're buying something, a standard that is commercially available, if your testing procedure actually sees what the actual chemical that you just injected into the instrument is. So I tend to find security in numbers and on the analytical side. That's my opinion. So I would go mostly with what the OCD says. But as you mentioned, they are phased out. So, I mean, I think that's where we probably just need to put it on to a vote and see, and we just go that route.
Yeah, I have another question for Commissioner Bloom. So based on how our chair described it, from his expertise too, in terms of chemical laboratory analysis point of view, how do you compare, let's say, the two definitions in terms of causing confusion, to, let's say, even the general public and also even to the industry as to which compound is even,
Yeah, sure. I think
Okay.
Dr. Campbell, that's a good question. I think the industry would easily understand either definition. I think they get at very clear subsets of chemicals. Listening to the chair speak, I come back to, Mr. Chair, I think we're here to widely protect health, not only pass regulations that can be enforced right now or for which there's a test. I mean, we have the opportunity to say, hey, this whole class of chemicals is off limits. We've seen, the devastating contamination of national waters and people's health and the presence of this in our blood. It's more affecting children and vulnerable populations. It's a concentrated impact on areas of oil and gas operations, and people should be, feel safe that all these chemicals have been taken offline for use in oil and gas, not just those which are enforceable today. And again, just because there's not a test for something doesn't mean that it also couldn't be, a violation or a violation that's dealt with in other ways or apprehended in other ways.
I just want to just make one clarification. As I stated, I am definitely more on the analytical aspect, just because I came from a laboratory standpoint. I'm very concerned about the environment and public health and safety. I think as Commissioner Bloom says, a lot of these compounds are definitely toxic to the environment. But I also want to urge and caution this commission, because we're saying all PFAS. As was brought out, not all PFAS are deadly. Paxlovid is something that we're taking. It has saved millions of lives with COVID. There is an SSRI that helps millions of people with their depression that are categorized as PFAS. So I think we just need to be careful when we're saying all PFAS, because the medical community, the scientific community, has found that some of these PFAS compounds are actually beneficial. So I am very distraught at the thought that there are chemicals that are destroying our environment, that are destroying our health and safety, that are categorized as PFAS. But I think we need to be careful with the word all. It's so inclusive when the scientific community and the medical community has indeed found PFASs that, with the definition of PFAS, are beneficial to us. So I just would want to caution that with the commission. And with that, I guess I stifled communication. So why don't we put it up for vote? So for Rule 1915.2, P as in Paul, number 3, the definition for PFAS, Commissioner Mpoma.
Can I abstain from this one?
We can see what happens.
Yeah.
I think it's too early in the day to talk about abstention. If you just want more time and further discussion or lay this one over, we can do that and return to the idea of abstention later.
Yeah, I understand the point, let's say where Commissioner Bloom is coming from, more or less putting a broader blanket on protecting the human health of precious people in the state of New Mexico. Now, the chair explained from actual, like, someone with expertise in this area. I'm not an analytical chemist, so that is why I'm just on the fence here. But I really wanted the chair to more or less look at the proposed definition from the proponent and then the OCD, and then seeing that neither of this, let's say all of this, all of this will ban PFAS utilization in oil and gas operations in the state. I will vote with Commissioner Bloom on this one. Thank you.
So you vote for Wild Earth Guardian's definition?
Yes.
Okay. Commissioner Bloom?
Yes, I vote with the proponent's proposal for PFAS chemicals.
Okay, excellent. I vote for the OCD's definition. So it is a 2-to-1. We will be going with the definition from Wild Earth Guardians for PFAS chemicals for 1915 2P3. Excellent. Thank you for that conversation. Our next one is just to make sure that I'm on the right page here, is going to be the changes in rules 1915.2. As in Tom, number 7, trade secrets. The Wild Earth Guardian's proposal is that trade secrets means information including formula, pattern, compilation, program, device, method, technique, or process that 1, derives independent economic value, actual or potential, from not being generally known to and not being readily ascertainable by proper means by other persons who can obtain economic value from its disclosure or use, and 2, is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. Am I reading the wrong one again?
No. Just want to clarify with the hearing officer, maybe that's some of the old language and now there's new language.
That's correct.
I apologize.
That's correct.
It-
So
I'm
OCD,
disconnected today. My sincerest apologies.
I'm sorry, Mr. Chair.
No,
The OCD is actually aligned with the petitioners on this.
so we don't need to discuss this one.
Trade secret means any information meeting the definition of the Trade Secret Act, basically 57-3A-2D.
Excellent. I need more coffee today. My apologies for being disconnected. Okay, so we don't need to discuss this one because they're both on, or do we?
So are you saying, so are we, OC, okay. There has been.
Since they're both
Okay,
on the
okay,
same
okay.
page.
Okay, yeah, thank you.
Well, the third party, I think, opposes it. So
Oh, I apologize. Does Namoga oppose it?
I think.
Yeah, Nemoga opposes that, but I will side with OCD on this one.
Madam Hearing Officer, are we correct?
Yes.
Namoga
Yes.
opposes it?
So on page 13 of NEMOGA's proposed findings and conclusions, their point, one point I see is trade secrets been used in other OCC regulations without definition and without a problem.
Mr. Chair, oh, I'm sorry, didn't mean to cut you off. I'm sorry. Let me take another swing at this. So, I don't know that we need the definition of trade secrets in here if we're not going to require companies to disclose everything that they're using. And again, I go back to some of the testimony we heard from opponents about, in Pennsylvania, they were looking for the health effects of fracking, oil and gas completions on the public in Pennsylvania. And they didn't know that PFAS was even being used in the secret sauce. And because they didn't know that, they weren't even looking in people's bloodstreams. And what you're doing here is you're doubling down on that. You're saying the public doesn't have the right to know what chemicals are being used unless there's an emergency, but routine use of chemicals and the how it comes into or invades our water, gets in the air because of spills, these 80 million gallons that have not been recovered. The 2/5 of spilled fluids on the ground are not recovered. This stuff's out there. I mean, this is why we need to disclose these things.
Commissioner Bloom, so I don't think the commission is saying that the companies don't necessarily have to disclose. I mean, if you look at Frac Focus, they are disclosing the ingredients. And I think we all agree that they should disclose the ingredients. But in terms of, let's say, having someone to look at it more like the cash number, then they are saying it's proprietary, right? So I don't think the commission, we are saying that we are giving companies the room to utilize any compounds, that can more or less impact the health of our people. At least they are disclosing the ingredients. And I feel like from innovation point of view, disclosing those, that one definitely, I'm not in favor of that. So, Mr. Chair, I don't know what we do with the rules 1915.2.7. I feel like we should still keep, especially when OCD and then the proponents are all in agreement on this one.
This one is kind of interesting, I believe, because both Wild Earth Guardians and the OCD agreed that trade secrets should follow what state statute is, 57-3A-2D. I understand that there are the concerns that NMOGA has, but this is trade secrets in this instance is something that is defined by state statutes. So for me, that both the petitioner and the Oil Conservation Division agree that trade secret is what our law states, what our actual state statute is, I think doesn't harm the oil and gas industry in any means. So that's my opinion on this. Should we just put it up for vote and see?
Mr. Chair, and I don't know, maybe Ms. Orth could elaborate on this a little bit, but if we do a walkthrough, I don't even believe we need to have a definition of trade secret if we're not changing anything about trade secrets, if we're allowing trade secrets to be maintained. I mean, that would just be the existing rule.
So
Otherwise.
before you answer, Madam Hearing Officer, are you suggesting that we just scratch this one completely? Is that what I'm understanding?
I think that might be where we're landing.
Okay.
Yeah, and Mr. Chandler may have his own answer on this. Typically, the lawyers looking at definitions and regulations believe it's unnecessary to repeat the statute unless you're modifying it somehow. But Mr. Chandler may have an answer here.
Mr. Chair, that sounds like sound advice. I'm looking through to see if the term is used in any other sections. And I think Commissioner Balloon's point is it's not used in any other section, so maybe there's no need for it, but I'll double check that.
So, Mr. Chandler, should we wait until you do your decision, or should we put this one up to vote? What's your suggestion?
If someone has access to the proposal attachment B on their computer and maybe just do a search or a control find, the computer might be faster than the human.
I'm having technical issues. Does anybody have it up? Give us a second and see if Commissioner Bloom can do it.
Secret. Yeah, no, it's not reading it as reading the words.
I exported it to Adobe.
So,
It's gonna let me.
so on page 8 of attachment A, number 1, the division does not require the reporting or disclosure of proprietary, trade secret, or confidential business information. So it is used only twice. The first one is the definition, and then the second one is what I just read.
So you mean under 1915-16-19, log completion and work over reports B, hydraulic fracture disclosure number 1. Is that what you're saying right there? The division does not require the reporting. So it does show it.
Okay. So then I'd go back to the hearing officer's statement that putting a rule in there that says trade secret is the definition, probably most lawyers would say that's redundant.
So strike it.
Mr. Chair, I think most lawyers would say just there's no need for it. It's yes, to strike it. But if you wanted to, if you felt like it was important to put that marker in there, you certainly have that opportunity.
Okay, so if there's then redundancy and there's no need to have redundancy, I'm going to move that this particular one, 1915-2, T as in Tom 7, gets stricken. Commissioner Mpoma,
Approved.
Commissioner Bloom,
I'll oppose on that because I think it might come back into play with some other discussion about what's disclosed and what's not.
okay.
I thought it was your motion.
I simply noted that it might not be necessary if we're not going to require disclosure of all chemicals. So
Yeah, now I'm a little confused too, Commissioner Bloom. I must admit that was the curveball because you started this conversation.
I think I started by saying if we don't want to talk about changing the way chemicals are made public or concealed from the public, that it doesn't really matter if we have that definition in there. And the next one we're going to come to is one called undisclosed chemicals, which also would not serve a role if we don't want to be transparent about what chemicals are being used and transported and spilled all over our state.
Okay, so before we just move on to the next one, I get it. You have your stick on this, but on this particular one, I think it's redundant as well. So if we're going to move on this, it's a 2-to-1 that we strike this one due to redundancy, and it is going based off of the state statute, and even petitioner agrees that the state statute is sufficient. So we just leave it at that. Excellent. Now I need to find my spot again.
Next up, undisclosed chemicals.
Undisclosed chemicals. There it is. So this one is Rule 19.15.2.U3, undisclosed chemicals. The definition that was submitted was that undisclosed chemicals means either chemicals that are listed without a chemical abstract service number in the FRAC focus database pursuant to 1619B and MAC, or if a safety data sheet lists ingredients that comprise less than 100% of the whole chemical product, those chemicals that make up any unlisted portion of a chemical product on a safety data sheet. The OCD, I believe, is stating that we strike this completely because it is related to trade secrets. Discussion.
Mr. Chair, so I still stick to my previous vote on this one, and I will go with OCD.
Commissioner Bloom?
Yes. And again, I support the proponents' inclusion of definition of undisclosed chemicals.
Okay, thank you. I think this one, I as well would have to go with the OCD on this one. And so I believe for this particular rule, I mean, this definition, it is again 2-to-1 for the, taking out undisclosed chemicals. And I believe that was it for that. The time is about 10:20. Did you want to take a break for 10 minutes and start back up at 10:30?
Yes.
Okay, let's take a 10-minute break. Thank you, everyone. Okay. We're back on the record. Our next rule to change is Rule 19.15.7.16.A.
Mr. Chair?
Yes.
I don't remember that the commission has addressed the deletion of the proposed definition for well site.
Keep it out.
Oh, okay, good.
Which word was that?
Well site, the
Okay.
definition of well.
Yeah,
site.
yeah, we dropped it. Yeah.
Yeah,
Okay,
that was
thank you.
dropped. Thank you, Madam Hearing Officer. So we're back on 19.15.7.16, well completion or recompletion report and log, the Form C-105. Mr. Chandler, I think you were going to kind of walk us through this one.
Thank you, Chair. There's different language provided by all three participating parties. And so I'm going to try to systematically go through it to assist the deliberations. So starting with paragraph A, which starts within 45 days. It appears that all three parties have agreement for those first couple lines up to including drill stem tests. At that point, the proponents wanted to add and the chemical disclosure list. Based on the earlier vote on rejecting that definition, I guess it's my working presumption that that phrasing will also not be adopted. Yeah. So that is the first sentence. The second sentence, all three parties start out the same. In addition, the operator shall file and everyone agrees to this phrasing, a certification that no. And then we have a differing view. The proponents want language saying undisclosed chemicals or before the phrase PFAS.
I'll make this easy. I would vote for the OCD language if that's helpful. Clearly, we've discarded undisclosed chemicals, so this starts to look pretty close to the OCD language starts to look very close to the proponent's language.
Okay, and that sounds very logical. The Oil and Gas Association, though, did want to have some language after in addition, the operator shall file a certification, and this is the new language they are proposing, that no PFAS has intentionally added to the hydraulic fracturing, completion, or recognition fluids used in the well. That's on page 16 of their proposed findings. So I hand it back to the chair for deliberations on the addition or non-inclusion of that proposed phrase.
So the phrase was that no PFAS was intentionally added to the hydraulic fracturing, completion, or recompletion fluids used in the well, correct? The word intentional?
Mr. Chair, that is one word, but it's all that phrasing is different than the OCD proposal, which just says added to the fluid used in the completion or recompletion of the well.
Okay. Commissioners.
I will side with OCD on this one. I believe, during the hearing, we discussed about the intentionality, but the question is who justifies whether it was used intentional or not. So I will side with OCD's definition, or let's say OCD statement right here, where it says that a certification that no PFAS chemicals were added to the fluid used in the completion or recompletion of the well, thereby rejecting NEMOGA's statement.
Okay, thank you, Commissioner Bloom.
Yeah, as Mr. Chair, as I just stated, I would be fine with OCD's alternative language. I believe that's well articulated.
Thank you. I would have to agree on the same reasons that the other two commissioners stated. So we will not add the part that says that was intentionally added, that phraseology. We'll go with the OCD phraseology.
Mr. Chair, then moving to B. B, all three parties agree on adding this phrase about this applicable form. So there is uniformity for my review on B. On B, adding that language.
Commissioners, any concerns with that?
No concerns from me. Sounds like they all agree to the same language, so I will agree too.
Okay, Commissioner Bloom?
I'm sorry, are we talking about the language that's
Subsection B.
okay? Mine kind of rolled over. So the language that says a copy of electrical and radioactivity logs, what we're looking at. I have B on mine. The next page. Yeah. I think we need to go back up for a moment because there's a little bit of difference. Or do we just adopt this other language here about on A, which says a copy of electrical and radioactivity logs run on the well with Form C-105?
I think it just kind of got the whole, and good point. So on part A, there was still the part where it says chemical disclosure list, but I think because chemical disclosure list was taken out, that would then go with what the Oil Conservation Division stated. Did NEMOGA have any differences on?
And let me, and Mr. Chair, if I could, I think we're missing a comma in here. This is where I'm going. If we stick with the OCD language, it says, if the division does not receive Form C-105 with attached certification, so it says certification logs and summaries. Is that certification comma logs and summaries? I think that's what we want is comma certification. It's not certification logs, it's attached certification.
There
which
is, so if you look at this copy here, let me look
Yeah.
So the comma is there. I don't know if it made it onto that particular page, but for Wild Earth Guardians and for the OCD, they do have the comma in there. Attached certification, comma, logs and summaries. They're just taking out the chemical disclosure list for the OCD.
So, Chair, are you saying with attached certification logs, or is it certification?
Comma logs.
Yeah, it should be certification comma logs. Yeah.
You both are saying that there needs to be a comma after certification, correct?
Yes.
All right, so Mr. Chair, if you're looking at the divisions exhibit 1, also exhibit 07, they do have a comma, and that is, as I noted in my footnote, any typographical errors in my outline was unintentional, that the party submittals are the official record.
Okay.
So, yeah, I think in what I'm looking at, I'm not looking at the pages that you are. I'm actually looking at what was submitted, and they both have both versions, even whether it's Wild Earth Guardians or OCD or NEMOGA, all three versions, there is a comma after certification. I think it's just a typographical error on the form that you're looking at. So it should say, if the division does not receive Form C-105 with attached certification, comma.
So, agreed. Now, I think we might want to take a moment and make sure that we're recording all this properly, so we get a good final draft, right? Is someone who's doing that for us? Are you doing that, Mr. Chandler? Or?
Mr. Chair, the hearing is being recorded and will be transcribed afterwards. I'm also taking notes.
Okay. Because I think in some ways we're working off attachment A. Attachment A has language in it that we just voted down, right? And so we might be having some issues with version management. I just want to make sure that we're making a good, clear record for ourselves as we move along.
So Mr. Chandler is taking notes. I am looking at him. As he mentioned, we also have it transcribed. So I think then just to go with what you're saying, Commissioner Bloom, if we continue in part A, where it starts, if the division does not receive Form C-105 with attached certification, comma, then it was added from Wild Earth Guardians to put chemical disclosure list, but that was taken out of definition. So now that is taken out. Then it'll just read certification, comma, logs and summaries within a specified 45-day period. The division shall withhold the allowable authorizations for the well or suspend injection authority as appropriate until the operator has complied with 1915-716 NMAC. Are you good with that version?
Yes.
Okay. Commissioner Ampoma?
Yes. I'm good.
Okay. Now let's move to B for this section, okay? Subsection B. Just to remind us again, Mr. Chandler, if you could just repeat.
Sure. So the existing language reads in B, in the case of a dry hole, a complete record of the well on Form C-105. Then I'm going to pause. All three parties have consensus on the following addition, comma, or if applicable Form C-103, comma, and then the rest of the existing language. So in B, all three parties have consensus on adding the new phrase.
So commissioners, are you good with that? Commissioner Ampoma?
Yes, I am.
Commissioner Bloom?
Yes.
I am as well, so that will be adopted.
Mr. Chair, C. I'll do the easy part first. The existing language reads, the division shall not keep Form C-105. Then all three parties agree on this additional language, comma, or if applicable Form C-103, comma, and then the remaining language for that sentence. So the first sentence, all three parties agree with adding a particular phrase.
Okay, commissioners, are you in agreement with this?
I'm good with that. The addition of, or if applicable, Form C-103. Yes.
Okay, Commissioner Ampoma?
I concur with that.
As do I. So that will go as was agreed upon by all three.
Later in that subparagraph C, there's the dispute about the use of the word shall and may. I will read the existing language into the record. It's the last sentence of C. This is the existing language. Upon such request, the division shall keep these data confidential for 90 days from the date of the well's completion, provided, however, that the report, logs, and other attached data. From there, the parties have a dispute whether it should be shall or may. According to my research, and maybe the hearing officer can, or the other parties, the other commissioners can help me with this. I believe the proponents and the Oil and Gas Association both have shall, where the division has may.
Yes.
I will certainly defer this one to you to decide on that because it's English.
Because it's English. Um, Madam Hearing Officer, did oil and gas also have shall?
That's correct.
And the OCD put in may?
That's correct.
Or retains may, I think is more appropriately the case.
Yes, that's
Okay,
right.
so
Retains me.
retains may and oil and gas and Wild Earth Guardians said shall.
That's correct.
Okay, so I'm not a lawyer. So Madam Hearing Officer and Mr. Chandler, my understanding is may gives us options, shall is concrete. It's pretty much a demand. It will happen this way. Do I have that understanding? Correct.
Correct.
Okay. So commissioners, based on that, since may gives gives the option, allows choice, and shall makes it mandatory. How do you go?
I think I need to understand better what's happening here. So see if we can talk this through. The division shall not keep the form C-105 or C-103 confidential unless the well owners request it in writing. Upon that request, the division shall keep these data confidential for 90 days from the well's completion, provided, however, the reports, logs, and other attached data may or shall, when pertinent, be introduced in a public hearing before division examiners, regardless of their request. So after 90 days, is everything public?
Madam Hearing Officer, do you have an answer to that one?
Well, so my understanding would be that it would be public after that. My concern here with shall is that it could be read to require a hearing even when one wouldn't be otherwise required. Whereas may is permissive. If there's a hearing, it may be introduced. But I shall was confusing to me there.
I must admit, I find it interesting that oil and gas also wanted shall in this. I'm not going to lie. I could see where Wild Earth Guardians would want shall there. I don't remember the testimony on this one.
So let me just offer then as to NAMOGA's justification that they reproduced in their final proposal document, the attached, was NAMOGA supports requiring operators to certify that no intentionally added PFAS were used. And as outlined in the pre-hearing testimony of Drs. Anderson and Richardson, the target is a prohibition on the use of PFAS containing fluids, and they wanted to properly capture the focus of the rulemaking. I don't see a specific justification of the change from may to shall.
And Madam Hearing Officer, can you, I apologize. As you were talking, I was trying to keep in mind your concern that you had with the word shall. Can you repeat it, please?
Just that I think the sentence is ambiguous on the question of then whether a hearing would be required, as opposed to allowing a party, giving a party permission to introduce this information in a hearing. That's one thing. But I was just concerned that maybe the word shall would require a hearing that might not otherwise be required.
Yeah, Madam Hearing Examiner, I take that to, I don't take it to mean that the hearing is required, but rather that the data shall be disclosed if a hearing were to be happening, right?
Right. And I guess I felt like may was
Yeah.
sufficient there. That's all.
Yeah.
I have to agree. I find it perplexing that both that oil and gas would want shall as well. I actually have to agree, me personally, with the division that may is actually more appropriate in this instance. So my vote is to go towards may. I'll give you a minute more to ponder this, and then I'll ask for your opinions as well.
I'll go with May as well.
Okay.
Still trying to figure out what this does or what it would change or. So part D says there's an addition there which says if there is a change in the information provided under this part, the operator must submit the change within 30 days. And then it goes on to say there's a change, new language from the joint proponents saying that the division shall retain each form C105 and C103 indefinitely.
While you're thinking this, Commissioner Bloom, Madam Hearing Officer, if we look at that sentence one more time, it says, upon such request, the division shall keep these data confidential for 90 days from the date of the well's completion, provided, however, that the report, logs, and other attached data, and then we have the differentiation of shall or may, when pertinent. If it's a shall, how does the phrase when pertinent play? I guess, because if it's a shall, then when pertinent is null. If it's a may, then when pertinent is something that would play a part. Do I understand that correctly?
That would be, I think, a reasonable reading of that sentence.
So then if this commission were to adopt shall, then we would probably want to take out the phrase when pertinent.
Right? And yet no party is suggesting that you remove when pertinent.
I know. That's what's perplexing with
so,
this.
Mr. Chair, your point is if it says shall when pertinent, it really comes back to almost a may, doesn't it?
Exactly.
Yeah.
Okay. So Mr. Chandler handed me, this is attachment B from Wild Earth's Guardian, and they stated on number 47 on page 17 that the change from may to shall in 1915-716C recognizes that the chemical data completed by this part will not be subject to a trade secret claim because all chemical disclosures will be made voluntarily. And as I stated, I understand why Wild Earth Guardians would want shall. I don't understand why New Mexico Oil and Gas wanted shall. I still stand on the way the phrasing is set, since no one questioned when pertinent, that automatically makes it a may, because it's based off of when pertinent.
think maybe where the proponents wanted to go was to delete may and when pertinent to get at.
We can't make that
more
assumption on the
disclosure.
when pertinent.
Right.
I mean, we can make our decision on when pertinent, but
Yeah.
I don't think we can make any assumption on what either side was thinking of in leaving when pertinent.
Well, I'll vote for shall because I did want to see more disclosure,
Okay.
and I'm in the minority. So there we go.
Okay. So you're going for shall.
Let's
I'm-
move on.
I'm going for may, and Commissioner Mpoma, are you for may or for shall?
For me,
Okay. So 2-1 for may on that one.
Mr. Chair, the next two are D and E. D is new language that all three parties agree upon.
Okay. So I'm just going to read it just to make sure that we just have it on the record. D states, if there is a change in the information provided under this part, the operator must submit the change to the division within 30 days after the date the operator knew of the change. All three parties did agree on this phraseology. Commissioner Mpoma, do you agree?
yes, I do agree.
Okay. Commissioner Bloom.
So I agree.
Excellent. So we all agree with that change for D.
Mr. Chandler, may I ask a clarification? Did you cover the 60 versus 90 days? No, it looks like Namoga wanted 60. But yeah, that's what's in their final proposal. So I'm looking at the final proposal from OCD. They say to keep 90. And I'm looking at the final proposal from the petitioner, sorry, that keeps it 90, but then Namoga's has 60. Oh, okay, so there's a difference then between their final attachment and their final statement of reasons. Okay, I'll
So,
withdraw the question.
oh, okay. So we'll just go with off of what Mr. Chandler has, which is what was it for Namoga, the final, what was it called? Proposed finding facts and conclusions of law. Okay. So everybody agreed on the 90, correct, Mr. Chandler?
If the reliance is based on the MOGA's proposed findings of fact and conclusions of law filed February 19th, yes.
Okay. Well, let's solidify it and we'll go that way. Commissioner Mpoma, for 1915-716C, there is the dates for 90. Do you agree with 90 days?
Yes, I do.
Okay, Commissioner Bloom?
I agree. Yes.
Okay, as do I. So we'll make it official, 90 days. Excellent. We just did D as in dog. Now we're on E as in Edward.
Mr. Chair, only the proponents have language for E. It reads, the proposed language, the division shall retain each Form C-105 and Form C-103 indefinitely.
Okay. I think the OCD's reasoning was to strike it because the OCD follows state's records retention rules. And my understanding is Namoga went with the OCD on this one, correct? Okay. Commissioners.
I would follow OCD's change their proposal there. I know that there are state retention rules.
Okay. Commissioner Mpoma.
I agree with that as well.
Okay, I too agree with that. So we're going to go with the OCD and follow state records. The next rule is changes to 1915-14-9C. Mr. Chandler, I'll just let you direct us on this one as well.
Mr. Chair, I direct the commission's attention to C, where there is some consensus among the three parties and some disagreement. C would be new language proposed as follows. An applicant for a permit to drill, deepen, or plug back shall certify that they will not. I pause because I believe all three parties agree with that phrasing. At that point, all three parties have different language. The proponents want, just give me a second.
I think the first part is that the proponents want any undisclosed chemicals.
Mr. Chair, if it's helpful, I would be comfortable with the OCD modification there, given that,
Well, let's break it up. I mean, I think Mr. Chandler, I thank you. I appreciate for
want
expediency.
to move, yeah.
Yeah, but I do want to just let's just document what exactly. So the proponents want undisclosed chemicals. That was taken out of our definition. So I think by default, that takes it out of this sentence as well. Am I correct, Mr. Chandler?
I'm tracking with you, yes,
Okay.
Mr. Chair.
So then our next part is before or PFAS. So the proponents added undisclosed chemicals, which is taken out, and then says or PFAS. The OCD says may not introduce any additives that contain PFAS. And what did oil and gas write for that one?
Mr. Chair, they will not introduce any additives. That is, strike that. They will not intentionally introduce any PFAS containing hydraulic fracturing fluids in hydraulic fracturing operations of the well.
Okay. So the petitioner put in PFAS in downhole operations of the well. The OCD put in additives that contain PFAS chemicals in the completion or recompletion of the well. And New Mexico Oil and Gas put in the intentional they will not
This is C, they mislabeled
oh,
it.
they mislabeled it. That they will not intentionally introduce any PFAS containing hydraulic fracturing fluids in hydraulic fracturing operations of the well. So those are the differences. Again, for expediency, I think Commissioner Bloom, you said, let's just go with the Oil Conservation Commission division's changes, correct?
Yeah, I mean, I'll walk that back. I mean,
Okay.
I do support the proponent's position here to obviously to disallow or unallow undisclosed chemicals. But you know, we've taken our vote on that and that's gone. So then at that point, I think the OCD modification makes sense.
Okay. Commissioner Mpoma?
Yeah, I agree with OCD's revision there. Now, I do have a quick question. So in the bill that we received some notes on, in there too, intentionality is a big part of it. So, I mean, assuming this passes, and then we've taken out all the intentionality throughout our entire deliberations here. Council, how does that impact, let's say, what we've done?
Mr. Chair, are you asking the question about intentionality, what the impact of that verb, or was it a more holistic question?
Yeah, so reading through the bill that we're briefed on prior to, let's say, the deliberations, I'm asking, intentionality is throughout the entire bill, right? So here, assuming, let's say, we strike out intentionally introduce any PFAS. So let's say, how does that, like, if this bill passes, how does that change, let's say, if we have to go with the OCD's revision?
Mr. Chair, if the bill in front of the legislature passes and is signed into law, then it's possible that some party may need to bring a new petition, even the government, to examine the ramifications of adding that legal term of art, intentional. But my advice from earlier this morning is that until that happens, the lay of the law right now is, the lay of the land is that has not passed. And that's actually not even from the proponent's proposal, that's from the Oil and Gas Association proposal. So I guess short answer is it may have to be reviewed if that law has that type of language.
Okay. I will agree and vote with to go with OCD's revision.
Okay. Excellent. I think I also agree with the OCD as well. So all three with OCD's proposal. Our next section is 1915.14.10, approval or denial of a permit to drill, deepen, or plug back, section A. Mr. Chandler, I'll turn it over back to you.
So Mr. Chair, try to break this into two different parts here. In the first sentence, we're looking at 10, correct? Correct.
Correct.
The director or the director's designee may deny a permit to drill, deepen, or plug back if the applicant is not in compliance with, I've just read the existing language. OCD has on its own proposed inserting an additional rule citation in, which reads 19.15.14.9 NMAC and then they continue with the sentence. So the first step is to decide whether the commission agrees with OCD and add in this second citation.
19, 15, 14, 9. That's the one we just talked about. Correct? Yes.
C.
19, 15, 14, 9. So that's the one that we just talked about.
So what this is doing is saying that if an applicant for a permit to drill, deepen, or plug back, not put any PFAS downhole, I think you're having to certify that. Sorry, rambling.
I think you're saying, okay, so if we look at 19, 15, 14, 9, it's applications. So I think what the OCD is trying to say is that if it's not in compliance with any part of this part 9, 19, 15, 14, 9, or if it's not in compliance with subsection A of 19, 15, 5, 9. Not or, and, sorry. So it needs to be in compliance for both sections for this to continue, is what the OCD is saying. Madam Hearing Officer, is that how you understand it as well?
Based on the failure to do a certification, that's what you're saying.
I'm saying my understanding is that the OCD here is saying that the director or the director's designee may deny a permit to drill, deepen, or plug back if the applicant is not in compliance with both of these groups, 19, 15, 14, 9, and subsection A of 19, 15, 5, 9. Am I understanding that correctly?
Yes.
Okay.
So the extra language, as I read it, addresses something other than a permit to drill, deepen, or plug back, which is to authorize the transport of non-domestic waste, including produced water. This is from the Guardians, the petitioner. So
I think what we're trying to do here is deny a permit to an applicant that does not provide the certification that no PFAS were used, right? And if you look at NMOGA's, hearing, I think it's the first of the documents they submitted, part 1. They get at this. There seems to be some unanimous concurrence that we want to deny permits to people that haven't certified they haven't used PFAS.
On page 810 of NMOGA's attachment, what they say is that they've stricken the other language because this rulemaking has nothing to do with the transport of produced water or non-domestic waste, has not been properly noticed to consider such issues. And so the focus for them should be on a permit to drill, deepen, or plug back, and attempting to redefine or equate produced water with or to non-domestic waste in their mind is legally not consistent with the law and the procedure.
So, Mr. Chair, I didn't lay this out as well as I could. What I was trying to focus on was first part, and then we'll get what the hearing officers.
I'm still on the first part.
I think what you've said is the first part by adding the additional citation is that the division is saying we now have an additional grounds to deny a permit. And that is if you don't do this new certification document in the application process.
So yes, so my understanding, because we're still just on the addition of 1915-14-9 that OCD put in.
I'm sorry for jumping.
No, that's okay. So 1915-14-9 talks about, I apologize, I'm jumping between here, talks about applications. What a person, what is part of the application. And so we've added in the PFAS, we agreed to the OCD's interpretation of C for 1915-14-9. So then the OCD is saying, traditionally, it had just subsection A of 1915-5-9. And if you go to 1915-5-9, that is compliance. So it's under enforcement and compliance. Subsection A states an operator is in compliance with subsection A of 1915-5-9 and MAC if the operator, and then it has 1, 2, 3, 4, and then number 4 has 4 subpoints as well, which talks about the financial responsibility, any orders that may be against the individual, how many wells can be active or inactive, etc. So in this instance, for 1915-14-10, the OCD wants to make it a little more stringent by adding in 1915-14-9. So you have to comply with 1915-14-9 and subsection A of 1915-5-9 to be able to proceed with an approval or denial or permit to drill, deepen, or plug back. And I said that all in one breath. Are you all in agreement with that?
Yes, I am.
Commissioner Bloom? It's adding both. Just as a reminder, it's adding both both rules.
Yeah, I'm trying to see what would drop out if we don't go with the.
It's making
Late
it even more
proposals.
stringent than what Wilder's
Yeah,
Garden.
I think I'm fine with the OCD modification.
Okay, so for that one, I agree as well. We will keep in 1915-14-9. Now we go to the second part.
Mr. Chair, after the second citation, and by that I mean subsection A of 1915-5-9 NMAC, the proponent and only the proponent has an additional 4 lines of text that the hearing officer was alluding to. That proposed language is and shall deny a permit to drill, deepen, or plug back any permit authorizing the transport of non-domestic waste, including produced water, if the applicant does not provide the certification required by subsection C of 1915-14-9 or provides a false certification, period. Their rationale there being the proponents on their proposed statements of reasons. 52, number 52 says, the amendment requires OCD to deny permits to any operator that will ensure that operators who do not comply with the new PFAS and undisclosed chemicals ban. This will help ensure compliance with the new regulatory requirements.
Okay. So discussion.
I will agree with both NEMOGA and OCD to strike that provision, because in there it talks about produced water and then also non-domestic waste, transport of non-domestic waste, which we did not really heard much about during the hearing. So, and also I do believe that this particular instance, we're talking about drilling permit, or let's say dipping or plug back on the well. So to me, including produced water and then non-domestic waste, more or less make it more complex. So I will go with NEMOGA and OCD to strike that.
Thank you, Commissioner Bloom.
I think I jumped ahead. Are we on?
So we are looking at 1915-1410A, the second part. So on your screen, so people, as you're looking at me, it would be this part in red for Wild Earth Guardians, this part in blue that was struck out by the New Mexico OCD, and the New Mexico Oil and Gas Association agrees with the OCD. Am I right on that? The New Mexico Oil and Gas Association agrees with the OCD on that second part?
Correct.
Okay.
For the same reasons.
Your microphone.
I think is for the same reasons as the previous section, I would agree with the OCD modification.
Okay. So I also agree with the OCD on this one, but here's why I agree with the OCD. I think the information there about the domestic waste, the transport of the domestic waste, including produced water, if the applicant does not provide the certification required by subsection C of 1915-14-9, we are with the OCD putting in that 1915-14-9, all of it is dependent on this denial or approval to drill, deepen, or plug is now dependent on 1915-14-9, then it automatically covers it. So if for whatever concerns there are with anything, then it's still dependent on 1915-14-9. So I just think that it's a little redundant. So I agree with the OCD as well. So I think all three agree to this change. Our next one is the proposed amendments to 1915-16. I believe we start with 1915-16-17A. Mr. Chandler.
Mr. Chair, I believe two parties have differing language and some overlapping language. The third party, the New Mexico Oil and Gas Association, in their proposed findings of fact, I could not find them a citation to alternative language. I did find finding 113 saying the OCC should adopt the NMOCD's proposed amendments to 1915-16-7, provided that further amendments are made to 1915-16-17 NMAC to more accurately track Mr. Powell's November 14th, 2024 hearing testimony and the written justifications that the OCD provided in exhibits 4-0044 to 4-0049. I'll pause for a second. I deferred to the hearing officer to help explain what Mr. Powell's testimony on November 14th might have been. And then I will resume with the comparing and contrast of the language.
Well, while you're looking that up, Madam Hearing Officer, Mr. Chandler, on that 113, they're proposing to go with NMOCD for all of 19, 15, 16, 17, or just this Part A?
Mr. Chair, the document I'm looking at, New Mexico Oil and Gas Association's proposed findings and fact and conclusions of law. Starting at number 113, I could not find anywhere where they provided.
So they're not differentiating between A, A1, A2, A3, A4. They're just saying all the changes in 19, 15, 16, 17.
Correct.
Okay.
So Mr. Powell said that as to the changes in 19, 15, 16, 17, refer to slides 22 through 27. I know Commissioner Ampoma was looking at the slides. They want to seek and codify OCD's authority and process if groundwater or surface water is threatened by downhole activities. The proposed subparts of the rule provide a pathway for OCD to conduct an appropriate investigation to determine if there are impacts to water. OCD believes the changes to this rule should establish a process for the detection of potential impacts, but not for their remediation. The remediation will be regulated by existing OCD rules regarding water impacts, such as 1915-29 and 1915-30 NMAC. The critical provision in OCD's proposed version aims to ensure proper identification of chemicals for which OCD may require testing and remediation under existing rules.
Okay. I think we should just go that this is a blanket statement from the New Mexico Oil and Gas Association, that they'll go with what the New Mexico OCD states as their rules, and then we can just go between the petitioner and the OCD. How does that sound appropriate to you, Mr. Chairman?
Mr. Chair, if there's anything from Mr. Powell's testimony that people remember and feel of such weight, then maybe they can wordsmith. But otherwise, I'm happy to proceed with the language comparison between the two alternative proposals.
Okay, let's proceed. And then if we have questions, we can go. Okay.
Mr. Chairman, I will start with A. The existing language starts out if. Both the proponent and OCD want to add the verb completing. The existing language then continues to read, shooting, fracturing, or treating a well. Both parties then want to add the language has the potential to negatively impact. The existing language then continues the producing formation, injection interval. Then both parties agree to add the phrase communicates with other strata. The existing language continues casing or casing seat or may create underground waste or contaminant fresh water. The operator shall within 5 working days notify. So I'm going to pause there. So both parties are in agreement up to that point here. Then the existing language says 5 working days notify and writing the division. The division wants it to read 5 working days, well, maybe notify the division in writing. Let me try this again. I'm pausing because one division is deleted and one I think is replaced. The proposal says notify the division in writing, then strike the division. That's what OCD wants.
I think it's congruity in sentence structure, because if you read, it says the Wild Earth Guardian says notify in writing the division, and I think it should mean notify the division in writing.
Okay.
I think that's what the correction is. And ironically, counsel from Wild Earth Guardians is nodding yes. No, not Wild Earth Guardians. Ms. Nanasi did so, and he said yes.
I think for our purposes, we don't pay attention to what they're nodding or
No,
not.
I
but
agree.
I think that the room understands what the language proposal is, and I have not explained it well for the record. But the two proposals as presented in the record provide the information better than I've said it out loud. Moving beyond that, then there is some dispute about the last couple words where the division wants to add the phrase loss of containment of any.
That's fine. Mr. Chair, I think we see a lot of similarities there between the Wild Earth Guardians proposal and the OCD modification. The OCD modification provides a little bit more nuance. I'd be fine with either, but would support the OCD modification.
So why do you support OCD's modification as well on the?
Yes, I think in this instance, I agree with the OCD as well. I think the one part was just a grammatical situation where the division and the division, and then they've added the loss of containment or any damage. I think that works for us as well. So all three of us agree with the OCD's version of this particular one. We'll document that.
Mr. Chairman, according to my notes, A1, both sides have identical new proposed language.
Okay, and I think they agree on this. So for A1, it just states diligence shall include, but is not limited to varying casing integrity and isolation of strata. This can include pressure testing in accordance with 1915-25 NMAC, performing casing integrity logs, cement bond logs, and any other means determined necessary by the operator or required by the division. As was mentioned, all three sides agree. Commissioner Poba.
I agree to that too.
Okay. Commissioner Bloom.
I'm fine with that as well.
Excellent. The next one is A2.
Madam Hearing Officer,
Sir,
may I raise a point of order?
okay.
I believe in this next provision that the commission will discuss, there is an issue that's related to a prior provision that has already been discussed. And the issue is whether the certifications will include all downhole operations or just completions and recompletions. And I don't believe that the commission discussed that issue. And so I just wanted to raise that is coming up now, but it is actually related to a prior provision, 19.15.14.9. And this was a matter C. Sorry, 19.15.14.9C, and that was a matter of significant discussion during the hearing. I just wanted to raise that. Thank you.
Thank you.
Madam Hearing Officer.
Sure.
I'm a little perplexed with what was just stated. And again, it may be that I don't have enough coffee in me, but I didn't understand.
He's noting that the issue of completions and recompletions was an issue of significant discussion during the hearing, and it was a heads up that it was related to another provision that was earlier discussed. Unless I got that incorrect, Mr.
I'm not understanding the heads up.
Okay.
Thank you, but I mean, I don't, I'm missing something somewhere.
I'm sorry, Mr. Davis.
Sorry.
Actually, let's just, we can't go down this road.
Right.
In a rulemaking. So if you're gracious enough to allow him to make a statement, if no one understands what it is, we can't go
Okay.
down this rabbit hole. We're just going to proceed.
Okay. Yeah, even better. Thank you. Okay, so let's just go with what we've got in front of us, 7A1. The proposal was that diligence shall include, but is not limited to varying casing integrity and isolation of strata. This can include pressure testing in accordance with 1915-25 NMAC, performing casing integrity logs, cement logs, and any other means determined necessary by the operator or required by the division. I'm sorry, that was 1. We're on 2. We did 1. My apologies. If damage from the shooting, fracturing, or treating of a well has the potential to impact surface or groundwater, the operator shall test for all chemicals disclosed in previous downhole operations and will use a third-party accredited laboratory to conduct any inappropriate testing. No, I don't think they mean inappropriate, but any appropriate testing necessary to verify any potential impact. The testing shall include all chemicals used in the well and may also include, but is not limited to PFAS, chemicals listed in 20.6.2 NMAC, and chemicals listed in 1915-29-11A5E NMAC. This may require more robust sampling than what is proposed by the operator if deemed necessary due to the nature of the potential chemicals. Of course, the OCD has differing opinion in this. So the OCD and Wild Earth Art Guardians agree to the first part. If damage from the shooting, fracturing, or treating of a well has the potential to impact surface or groundwater.
Mr. Chair, I think a lot of the additions in blue here are necessary only because we have allowed the continuation of trade secrets.
Correct.
Yeah.
So I was just going to go there. I'm going to just quickly, I promise I won't take too long. I will quickly differentiate. So they agree on that first part up to groundwater, comma. Then we have the change here that the OCD put in. Then the operator will disclose to the division all additives used in the applicable fluid stream, including trade secret additives as necessary to identify all potential contaminants. If trade secret chemical information is received by the division will hold the information confidential as required by 1978 NMAC 14-2-1 based on the chemicals identified by the operator and the division. The operator will test for all identified potential harmful chemicals and will use the third party. And they took out some of the other parts, such as shall include all chemicals used in the well and can elect to request. Discussion.
Mr. Chair, so I think this one we've discussed that previously, and I do like this provision a lot because here we are giving NMOC the authority to request for any undisclosed chemicals, including trade secrets, especially if there is any problem. So that also means that we are not necessarily saying that, let's say, all trade secrets should never be disclosed. You know, here OCD will have the authority to request for any undisclosed chemicals, which more or less probably might have been marked as trade secret. So I do support the revisions that OCD is proposing on this.
Okay, Commissioner Bloom.
Well, I'm back in a fix again because given that we have continued to allow trade secrets, the OCD modifications would make sense, although I don't approve of that continuance of the trade secrets. So I guess I would vote against this, but given where we have gone, this certainly makes sense. I see that another not insignificant change is that the testing won't be of all chemicals used in the well, but rather chemicals of concern. And I think that makes sense. So seems to be well put together given where we're at currently in our discussions.
Okay. Thank you. I will agree with the OCD on this one as well. Our next one is 1915-16-17A3. The proposal from Wild Earth Guardians is if it is deemed there is an impact to surface ground water, the operator shall report the impact as a major release in accordance with 1915-29 NMAC and respond accordingly. The OCD does not have any modifications to this. They agree. Commissioner Ampona.
I also agree to that as well.
Okay, Commissioner Bloom.
I agree.
And I agree as well. Excellent. The next change is 1915-16-17 A4. If testing reveals the presence of PFAS or undisclosed chemicals, the division may take enforcement action pursuant to 1915-5 NMAC. Did I read that one right? I'm reading off of attachment A. I'm not reading the council's notes. I'm reading attachment A. I read it straight off of attachment. Madam Hearing Officer?
Right, I'm looking at attachment A as well, which was filed the same day as their closing brief, February 19th.
So this is correct. Okay, so the question, the statement from Wild Earth Guardians under attachment A for 1915 16-17 A4. If testing reveals the presence of PFAS or undisclosed chemicals, the division may take enforcement action pursuant to 1915-5. Am I missing something?
Well, I feel like we're missing something here too. Let's take a second.
But then we have NMOGA and OCD both striking what must have been earlier language. If testing reveals the presence of PFAS or undisclosed chemicals, the division may revoke authorization to operate upon consideration of whether the current operator or previous well owner's operations contributed to the presence of PFAS or undisclosed chemicals.
Yes, if they still oppose this revised version.
Mr. Chair, I think it looks like
There's version differences in this one.
and you're looking at
I'm looking at attachment
A, yeah, which I think works from the OCD standpoint because it gets rid of withdrawing operator authorization, which the OCD says it doesn't have. Just says you can take enforcement action.
Madam Hearing Officer,
Sure.
in instances like this, because this is the massive incongruity. Because if we look at what the Oil Conservation Division has struck out, it doesn't read what was submitted in attachment A.
Right. So the attachments to the post-hearing briefs were allowed to differ from original proposals so long as what they propose as kind of their best and final offer is based on evidence in the record. And that I suspect Mr. Chandler would support that statement.
So is this commission to proceed on the assumption that the Oil Conservation Division disagrees with the statement since it differs?
So NAMOGA and OCD both believed that what must have been in the original proposal from Guardians needed to be struck, which is if testing reveals the presence of PFAS, they can revoke operating authorization. So Guardians' final proposal is not does not include the notion of revoking operating authorization. It is simply says the division may take enforcement action pursuant to 1915-5.
Commissioner Mpoma?
Yeah, I think either way, OCD's response to that still applies.
Well, this is a substantial difference though, Commissioner. I mean, if you read what they wrote in attachment A, it states if the testing reveals the presence of PFAS or undisclosed chemicals, well, we struck out the word undisclosed chemicals, the division may take enforcement action pursuant to 1915-5.
Not a different one?
I see where in OCD's original hearing comments, it says the OCD does already have other enforcement regulations codified under 1915-5, which can include a number of sanctions. OCD did not seem to need to restate that.
Agreed. But here,
And I guess my concern here is this new language is a very late addition that other parties haven't had a chance to respond to. So, and even previously, OCD was going to strike the suggested language, but it believes that it already has the enforcement capabilities. So
Yeah.
it might be fine without number 4 here.
I was gonna, and that's where I was going. I was gonna offer the two options. We either sit and we dissect this one, or we strike it. We go under the assumption that the OCD says we already have authority under 1915-5. This is redundant.
Yeah, that was my thought too.
Okay.
Even reading both, it still feels like OCD believes that they do have the enforcement authority. So 4 probably not needed.
So you agree, your vote is to strike number 4
Yes.
completely? Okay.
Yes.
Commissioner Bloom. I was pulling up 1915-5 to look myself. I have it up.
Yeah. So the main aspects of 1915-5 are compliance, enforcement of statute and rules, civil penalties, hearing procedures. I think given what we're seeing here, given the prior comments from OCD, I think I would be good moving ahead without number 4 and not risking having something in there that was not open to the other parties to discuss.
Yeah, I have concerns with a late stage change like that the other parties didn't get to discuss. So I think we all agree strike number 4. Now, on attachment A, did we have anything on 1915, 16, 17B?
Mr. Chair, it appears that the OCD matches or I believe, matches the guardians. So if completing, shooting, fracturing, or chemical treating results in the wells irreparable injury, the division may require the operator to properly plug and abandon the well and take any necessary actions to mitigate any resulting impacts. That appears to be an exact match there. And Namoga is not too far from that. Although it is different. If the well integrity event from completing, shooting, fracturing, or treating a well results in the well's irreparable injury, the division may require the operator to properly plug and abandon the well and take any necessary actions to mitigate harm to human health, animal, plant life, or property.
Okay, I just want to double check something. I pulled up 19, 15, 16, 17. I just want to make sure that I pulled up the right. It's 19, 15, 17, 19, 15, 16, 17. Yeah, so 19, 15, 16, 17 is just one paragraph, and we were adding all of the stuff. So is subsection B now also introduced? Is that what I'm seeing?
No, Mr. Chair, I believe there is an existing B. There might be some confusion because OCD marks that as D as in dog, but it's just clearly a typo. Should be B as in boy.
Madam Hearing Officer, we've pulled up the actual NMAC and there is no B.
Or A, for that matter.
These were being created.
Okay.
Okay, so I asked Commissioner Bloom to pull up and we both have the same page of 19, 15, 16, 17. I'm trying to.
Does not exist
Can we turn
at
off our
all.
mic? If we're not using the mic, let's turn it off because of the background. 19.15.16.17 currently in the NMAC states shooting and chemical treatment of wells, and it is literally 3 lines. And so we have increased it with part A, and then adding the subsections under A, and then under Wild Earth Guardians attachment A, they added a paragraph B. There's a lot of A's and B's in that sentence. Am I reading this correctly, commissioners? You're muted.
So, Mr. Chair, if we go to page of the PDF 45 of OCD's exhibit, there is substantial information related to this.
Yeah, so we expounded the paragraph from just 3 lines for 19, 16, 17. I'm sorry, 19, 15, 16, 17. From 3 lines to a paragraph, subsection A. And then A, we added subsections to that. 1, 2 was 1 and 2, and 3. And then according to attachment B of Wild Earth Guardian, I'm sorry, attachment A from Wild Earth Guardians, there's also a paragraph B now.
I think we jumped ahead somewhere here.
Yeah, but I'm going off of the electronic version of attachment A.
We went. We went
16, 17, A.
16, 17. Did we deal with 14, 10?
Yes,
Yeah, we dealt
because we
with that.
added that sentence.
That's right. Yeah. Okay. We did that. Okay.
So then if you look, so your printed copy is the same as my electronic copy, Commissioner. So we're here, there's this part B,
Mhm.
but
We
no,
didn't discuss this yet.
we did.
We did,
We just did all that.
yeah.
So for number one,
Yeah.
so A1, there was no changes. We agreed. Both parties agreed.
That's right. Yeah.
A2, we went with the
Yeah.
OCD changes. A3, everybody agreed, so we went with that. A4, we just struck it.
Yeah.
Then there is this paragraph B, as in boy. The original NMAC does not have a paragraph B. So Wild Earth Guardians is submitting changes.
Madam Hearing Officer, I think I can clear this up very quickly just to say that that new paragraph B, the paragraph itself, the B, the letter B is new. The language that's not underlined is existing language in the NMAC, which has been separated into a new paragraph. So the if shooting, fracturing, or chemical treating results exist in the NMAC currently, and that's why it's not underlined.
Right, and it's in black ink rather than red.
So if you can just let me in, if you just indulge me just one second. Mr. Davis, you said that you basically have taken the existing paragraph in 19, 15, 16, 17 and made it now part B with modifications. Is that how I understand it?
Mr. Chair, that's correct. I believe that OCD's proposed red line also did the same thing. So the last sentence, the last sentence of the current NMAC provision, 19.15.16.17, that last sentence is now broken into a new paragraph B. And that's, I believe, what's causing the confusion.
Thank you for the clarification.
Right.
I see. So they split
They split
16,
those two
17,
sentences.
those two sentences doing A and
and
B.
made A and B.
Yeah.
Okay. So,
So the A should have been in red as well. Yeah.
yes.
That's what.
Okay. So now let's just look at what was, they took that second sentence and made it its own paragraph and stated if completing, shooting, fracturing, or chemical treating results in the well's irreparable injury, the division may require the operator to properly plug and abandon the well and may take necessary actions to mitigate any resulting impacts. Though it's not a slide from the OCD, and it's not a slide that anybody has commented on, Commissioners, your thoughts?
I do not have any objection to the B.
Okay.